Mr. Murali, Pillai.
Mr. Speaker, sir, I support the bill, which in my opinion is a mountain appearing as a molehill. Its title is the Lease Agreements for Retail Premises Bill. Its spirit, though, is a deep rethinking of the moral limits of markets. Markets in Singapore, as in almost every country in the world, are created not only by supply and demand, but by laws that regulate them. Being one of the most competitive countries in the world, Singapore takes a light touch towards constraining the freedoms of markets. And most of the time, this has been the case, both because of the need for efficiency and the belief in the wise decisions of a relatively unfettered marketplace. But let us make no bones that in Singapore, a nation founded on the back of a socialist political philosophy, the market bends for the public good. And through this bill, the government has demonstrated that it's not shackled by the positions it took in the past and is willing to constantly review its policies to ensure that they address the needs of our people and enterprises. 5 years ago in this House, in my adjournment motion speech entitled Power Imbalance in Contracts Involving Small Businesses, I highlighted the onerous nature of contractual clauses which were, as a matter of course, imposed by the dominant players in the market against the small businesses. I specifically highlighted landlords of retail malls, particularly the REITs, as one category of dominant players. In my speech, I recounted how a demolition clause, which is a clause that allows a landlord to pre-terminate a lease with a tenant on the basis that he has decided to undertake renovation work without any compensation to the tenant, works unfairly against many tenants. These tenants would invariably have incurred capital expenses to fit out the premises, and they were left to bear these losses themselves. This does not appear to be a fair sharing of business risks. I also highlighted other onerous clauses imposed by landlords in my speech. This asymmetry adds insult to injury when we remember that tenants are small businesses and landlords are owners of large assets. I advocated those small businesses to be provided with statutory protection in Singapore beyond the Unfair Contract Terms Act 1977. I shared the examples of small business protection modes in UK, Hong Kong, US, Germany, and Australia. In response, the Honourable Senior Minister of State for Law, as she then was, Ms. Indrani Raja, stated that whilst the government was, and I quote, empathetic to the challenges faced by SMEs, unquote, the government's underlying philosophy is that, quote again, in general, free market principles should apply, and the government should only intervene when necessary, for example, to address systemic market failures, unquote. She also said, quote, enacting such legislation in Singapore can cause market distortion and eventually market inefficiency to the detriment of all, unquote. She also said to the effect that an answer to what constitutes a fair dealing is not something that is always clear-cut because different parties may have different views. Finally, she recognized that fundamentally, the issue is that of bargaining power and suggested that SMEs leverage on government schemes to scale up their business capabilities and use business and trade networks, such as the Singapore Business Federation. The introduction of this bill, 5 years since, represents, in my respectful view, a significant shift in the government's position, which I welcome. I listened to the Honourable Minister of State, and I noted that the pandemic posed to be a catalyst for this change. And this is a great example of how one turns crisis into opportunity. It recognizes that free market examples are not the holy grail of public policy, that these principles must bend to larger principles of public life. Let me point out what these are now. First, equality. This bill recognizes that landlords and tenants stand shoulder to shoulder, both with legitimate interests. The Honourable Minister of State referred to the relationship as a symbiotic relationship. They share a mutual goal of collaboration to ensure that Singapore continues to have a vibrant and competitive retail, F&B, and lifestyle sector. In this, the bill gives teeth to a code of conduct in which it's expressly stated that one key objective is to provide guidance to landlords and tenants to enable a fair and balanced position in lease negotiations. The beauty of this code is that it's put up by a committee representing both the interests of the landlords and tenants and consists also of neutral parties. The expectation is that the committee can provide holistic guidance on what constitutes fair practices in the context of retail lease agreements. Earlier, just before the break, the Honourable Member, Mr. Louis Chua, had suggested that perhaps the government should consider more data transparency guidelines in favour of tenants. On its own, it's not a controversial point, but my suggestion is this. We have this committee that is supposed to come to a consensus, a collective action plan. And in that regard, one would have to not just look at specific issues, but really the net picture. And in that regard, we always must take a give and take approach. So when we take issues or advocate issues pertaining to the tenants, we must also consider what are the landlord's issues. And then we can come to a consensus and hopefully we can move forward. The Honourable NCMP, Mr. Leong, had advocated some form of low rent control. And I've been in legal practice long enough to remember the spectre of the Rent Control Act. In those days, because of the Rent Control Act, there was no real investment by the landlords on their premises, leading to dilapidated buildings. And in the end, Singapore suffers because small Singapore would require a high utility of our land. So what is fair in the circumstances would have to be determined by market, and now we have this framework in terms of a committee, and we need to take a consensual approach to deal with all these issues. Now I come to the second point, fairness. A plain reading of the code will show that the focus is really to protect the small tenant and not the big landlord. I welcome the government's decision to intervene for the small tenant in the retail sector. It's a matter of fairness. It also makes business sense in the long term, because otherwise we would see a hollowing out of SMEs, which are representative of our nation's entrepreneurial spirit within the retail sector. There's a third principle that this bill makes provisions for, but in my view, it's not gone far enough. This is a true freedom to contract. I'd like to invite the Honourable Minister of State to state the government's position on power imbalances in contracts involving small businesses which fall outside the purview of this bill. And this is a point that the Honourable Member, Mr. Louis Chua, also made. I also wish to draw attention to contracts made by small businesses with other dominant players, such as telcos and utility service providers. Thankfully, where dominant players are regulated, I see an ability on the part of the regulators to rein in unfair practices and ensure fair dealing outcomes through exercise of their regulatory powers. This is done, for example, by the MAS, which issued fair dealing guidelines in 2013. I suggested in my 2018 speech that other regulators follow suit. What would be useful in particular is to ensure that the contracts issued by dominant players which are regulated are reviewed for compliance with such guidelines too. In other words, there should be no gap between regulation and contract. I now turn to the bill. Part 4 of the bill provides the dispute resolution mechanism that may be invoked by a landlord or a tenant should there be a complaint that there has been a non-compliance with a leasing principle set out in the Code of Conduct. This dispute is to be resolved through mediation first. If mediation doesn't work, then it's proposed to be dealt with by an adjudicator who will have the power to not just determine whether there's non-compliance with the leasing principle, but also to deal with the issue of compensation. Under Clause 10 of the bill, the Minister may authorize any person to be an authorized dispute resolution body. In turn, the authorized dispute resolution body must maintain a panel of mediators and adjudicators. My first question is, what are the proposed qualifications of the mediators and adjudicators? Also, why is it felt that the appointments of the mediators and adjudicators should not be done directly by the Honourable Minister? My next question concerns the power of the adjudicator. Under Clause 25.4 of the bill, the adjudicator must make a determination whether there has been non-compliance with the leasing principle. In such a case, the adjudicator may vary the lease agreement to correct the non-compliance, or he may order compensation. May I clarify that notwithstanding the use of the word "or" in the clause, the adjudicator may, in suitable cases, be able to order variation of the lease and also order compensation for the period before the order to vary is made. In addition, may I ask, what are the principles upon which the adjudicator is to calculate compensation? Is it based on the law governing damages for breach of contract? Or can the adjudicator decide on compensation in accordance with his own views of what is just and equitable in the circumstances? How would he deal with clauses in the lease agreement that attempt to exclude or limit liability for compensation? Moving on, it is proposed in Clause 13 of the bill that where there are any proceedings before a court in respect of a matter that is subject of Part 4 of this bill, the court may order a stay of proceedings on terms that it sees fit. If the legislative intent is to ensure that the adjudicator and not the court handles all complaints of non-compliance with leasing principles, would it not be better to provide that the court must grant a stay, save for limited circumstances, instead of making it discretionary? I'll be grateful for the Honourable Minister of State's clarification on this matter. If indeed it's intended that the court be vested with the discretion, may I ask the Honourable Minister of State, what factors must the court weigh in determining whether or not to grant a stay, having regard to the legislative objective of this bill? I also seek a clarification on the ambit of Clause 28 of the bill. It allows a party to raise challenges to the lease agreement on the basis of whether or not it complies with the proposed act in separate court, arbitral tribunal, or other dispute resolution proceeding. At first glance, it seems to be that Clause 28 may not be congruent with the legislative intent to channel disputes arising from the act to the adjudicator. Finally, I deal with appeals from the decisions of the adjudicator. I note that there's no provision specifically providing for an appeal. However, under Clause 27(4) of the bill, it is proposed that a party may commence separate proceedings in the General Division of the High Court to set aside the adjudication determination subject to the provision of security. Under subclause 5, a non-exclusive list of grounds are provided for the purpose of setting aside the order. In essence, the grounds are illegality and palpable injustice. I'd like to seek clarification from the Honourable Minister of State whether the intent behind the provision is generally not to allow for appeals from adjudicators' determination, save for narrow and extenuating circumstances. If that is the case, would the Honourable Minister of State please clarify the reason for doing so? I ask this bearing in mind that the adjudicator may have to apply the law governing contracts as determined by courts to issues at hand, for example, compensation and dealing with the enforceability of exclusion and indemnity clauses. Since what constitutes such law are matters within the province of the courts, I would have thought that should be recourse to the court system as a matter of right. An alternative option would be to allow for an appeal if it raises an issue of law. Mr. Speaker, sir, I conclude by offering my support for this significant piece of legislation which shows the government's understanding of the moral limits of the market. It gives life to everything I had imagined in my adjournment motion speech 5 years ago. I thank the Minister of State for this important piece of legislation. I should also thank the Minister for Trade and Industries here as well. To my colleagues in this House, may I be allowed to share that in parliamentary life, sometimes time is a secret ingredient. In time, we have recognized that there are power imbalances which do not work, not only because they oppress small businesses, but because they do not respect the general public good. In promoting fairness, equity, and true autonomy in contracting, we achieve the rare feat of a win-win solution. Surely this is a very good deal in the marketplace of ideas. Thank you.